What you know, alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Tuesday, March 11th. Hope you guys have had a good day so far. Beautiful day here in South Carolina. It's in the 70s, sunny. So when I get done, I'm porching it for the rest of the evening. Lori Vallow had a pretrial hearing today and they covered a good bit, so let's jump in. The judge tells Lori he has her motion about her request that cameras not be allowed at her trial, which is coming up soon. March 31st. Lori said she would like to add some case law to that, and she cites Shepard versus Maxwell. Supreme Court Justice Clark said a failure of the state judge in a murder prosecution to protect the defendant from inherently prejudicial publicity, which saturated the community to control disruptive influences in the courtroom, deprived the defendant of a fair trial consistent with due process. She also cites Arizona versus Cheney and says the defendant is entitled to a fair and impartial trial when publicity pervades court proceedings to the extent the proceedings were prejudicial to the defendant. She tells the judge, obviously, you've read my filing, but I wanted to add those. The judge tells Lori her prior attorneys filed a series of objections to media coverage or media being allowed in the courtroom, and he made a prior ruling on September 4th, which was fairly comprehensive, and he is inclined to allow one pool camera, but says he will issue a more detailed order later today or tomorrow. He did point out there will be no media coverage during jury selection. Someone from Court TV asked if they could live stream in real time, which is their preference, but the judge asked if they could do a 1 or 2 minute delay, and of course they said okay. The representative from Court TV did say when they share footage with the pool, they can't share that time delay, so his order would need to specifically say there is a 1 or 2 minute delay. Lori asks if they cannot zoom in on her notes, and also they like to have the camera on me at all times. So when the judge is speaking, can the camera be on you? And the same with the state and so on. And she asks if they could add that to his order. The judge said his draft order says no zooming in on counsel table or notes. As far as what they focus on, it's limited to the parties, him as the judge, the witnesses, but no jurors. The judge asks if there is a protective order for victims testifying. Who is the designated victim advocate and will they be testifying? The state says that's Kay Woodcock for this trial, and yes, she will take the stand. Both parties are ready to proceed March 31st. The state says their case in chief will take 2 to 3 weeks, but that's considering there is no defense attorney but Lori representing herself. They estimate 5 to 6 weeks total for trial. That would put us in the first couple of weeks of May of when they expect the trial to wrap up. To ensure they're not asking the jury to stay later, the judge thinks it's best to screen for 6 weeks. The state points out the jury could be outside mixed in with media, and also that goes for witnesses as well. The judge said he can give rooms for victims and witnesses to separate them from the media, and as for the jury, he can bring them up in a separate elevator. They move on to the jury questionnaire and jury selection. He's planning on sending out an e-questionnaire and also a remote questionnaire for the first 200 potential jurors. He needs a witness list and would like to send a draft of the jury questionnaire to all parties by the end of the week. Those would be sent to jurors by March 20th, and the cutoff would be the 27th. And then at that point, they would start to go over them. On March 31st, the first day of jury selection, they would decide who needs to be let go from that first group based on their answers. The next morning, which would be April 1st, they do expect to have some walk-in jurors who would need to fill out the questionnaire, and then they will deal with them then. They'll do in-person voir dire and then bring in another 200 prospective jurors on April 2nd, and if need be, another 100 on the 3rd. Once they get to 15 or 16, they're pretty much done, and they also can do panels of 20 with these large groups coming in. He expects to lose a lot of these potential jurors to prior media coverage. He said he typically would not put the defendant's name on the e-questionnaire, but in this case, he feels like it's necessary to see if anybody has formed an opinion. Lori says her issue, it could be bad if you do or bad if you don't. Her experience is that people will want to be on this jury, even if they say they don't know her. The judge tells Lori that the e-questionnaires would probably help people answer more truthfully. That will focus on her charges, a list of the witnesses, their opinions on Lori, or the case in general. They'll question more people in person as well. Lori said in her last trial, we went through 1,900 jurors. She would prefer individual voir dire, and the judge isn't opposed to that, but it will be a day of kind of decision. If they do one-on-one questioning, it could extend jury selection into that next week, but his hopes are that openings are by April 7th. April 24th will be a half day, and the judge says that they'll have something in there about jurors looking at wounds as part of the evidence, as some people are very sensitive. They move on to 2 motions for discovery that Lori has filed. The first motion is asking about communications between the deputy attorney and law enforcement agencies. The state says they have disclosed all communications. Lori says they've received 6 emails, and it seems to her in the last email, it ends with a question mark, which she said was probably answered, but there were no more emails. She says we don't know why they're not being provided or what the state is possibly hiding. They want the state to turn over everything they have left. The judge says some communications are likely by phone and were not captured. But based on the state's response, I can't tell them to turn over what they don't have. They say they have complied with discovery. The second motion was a request for video interviews, but the state's response says there was an interrogation room that was recorded, but not on body cam. Lori says there was a video recorded in the interrogation room that was not on body cam, but on a fixed camera. Lori says the body cam was turned over and she got 4 separate clips of that. She says this was actually from a full 2-hour video released to the public, and she would like for that to be turned over to the defense. The state says these are on body cam and were turned over. Lori has requested everything from the Gilbert PD, and the state isn't sure what Lori means. Lori says it's an interview with her daughter, Tylee Ryan, and Melanie Gibb. Lori said she did not know she was being filmed the whole time she was in the interrogation room, but the state says they have disclosed those. Lori says they've been given 4 12-minute body cam videos and they go in and out. They're all mixed up and they're not the full one. She says her understanding is the full 2-hour video recorded is from the ceiling and it's online, but it's not in discovery. I have these videos on my YouTube page. I will link those in the description, by the way. The state says they have provided those. The judge asked Lori if she has seen the video. She says her previous mitigator showed her parts of it. Lori did not know about it, but the mitigator told her it's online. The judge asked the state to follow up with the Gilbert Police Department and says if it's out there, then it should have been disclosed. The next 2 motions are motions in limine regarding Alex Cox and Tylee Ryan's statements. The judge asked Lori if she is referencing out-of-court statements. And there are exceptions to the hearsay rule, and how do Alex's statements fit? Lori says the state is blanketing that whole thing, and it should be a case-by-case basis. She says, I don't think the police interview falls under hearsay. And the judge asks why. Lori says they're not using it for the truth of the matter asserted. They're using it to corroborate circumstances, which is everybody came in and told their same story, which corroborates facts, but not being used for the truth of the matter. She says what me, Alex, and Tylee determined how they acted after, treating it like it's self-defense. All of that is relevant to the defense. It was self-defense, and Alex's statements apply to some of the rules of exception. She cites 803 and 804, some of his statements, but not all. The judge asks which one. And Lori says statements on body cam in the driveway at the residence when police arrive. The judge again asks what specific statements are allowed in. Lori says present sense impressions at the house. The judge says that means when you're observing something and talking as it's happening. The judge asked if she is talking about what happened prior, and Lori says yes, prior. The judge said that's not a present sense impression. Lori then says, then 8032, which is excited utterances. He was under the stress of the whole situation when he made the statements. The judge asks about Alex's demeanor, and Lori said he was upset. What did he say? Lori says, I shot my brother-in-law in self-defense. He hit me with a bat. The judge wanted to know how soon after the shooting did Alex say this, and Lori said immediately, or as soon as the police arrived, but she wasn't there and doesn't know how long after 911 was called that the police arrived. Lori said Alex's state of mind was he was scared. Lori says in the state's reply to her, they didn't think 805 applied, but she didn't see an and after, but there is an and after part B. It accurately reflects Alex's knowledge, but the judge tells Lori part B is a recorded recollection like writing it down or doing a voice memo. The state has not decided if they will introduce Alex's police interview in the trial. They point out that 911 was called around 8:30 and then police arrive. There is body cam with that video. And then later, after 10 a.m., Alex is brought to the police station for a more in-depth interview. If the state brings in statements from the house, they may bring them in as co-conspirator statements. And then the state says they can bring in hearsay against a party. The judge asked if the state will introduce Tylee's statements. No. No statements at the scene were given other than her identifying information about herself. Her statements were all made at the police station. My understanding is they are not going to bring anything Tylee said into this trial. If I got that wrong, let me know, but that's what I took from it. Lori says 8033 is the mental, emotional, and physical condition, Tylee's state of mind, and the indictment says Charles told Tylee, if you hit me with that bat, you're going to jail. Lori said Tylee was scared to say she brought the bat into the equation because of her fear of going to jail, and that was her state of mind at the time. The state says they will bring in that Lori has been found guilty by a jury of killing 3 people and point out Lori cannot benefit from killing a witness, in this case that would be Tylee, and then try to bring in her statements for Lori's benefit. They think it would be improper. The judge says there's been a judicial finding that the witness, meaning Tylee, is unavailable, and it is because of Lori's actions. And the state says yes, after a jury trial, she was convicted of killing Tylee. The judge said the court, on a preliminary basis, is going to preclude references to Tylee's statements. If there is a reason where a door may open for Tylee's statements to come in, he asked that Lori request to argue that outside the presence of the jury. As far as Alex, he's going to rule on a statement by statement basis, but the judge is skeptical of statements coming in that were made hours after police were there. He will rule on statements at the residence when they are introduced. The state asks that Lori submit to fingerprint, palm print, and footprints being taken as well as photos. That would be to tie her to any other convictions. They plan to do that at the next hearing on March 18th. The judge asked if Lori plans on calling an expert witness, and she is. Lonnie Dworkin. This guy testified in the Jodi Arias trial for the defense, by the way. He is a phone and digital expert. However, Lori has not submitted his expert report. The judge reminds Lori expert reports are due 30 days before trial, and if she is going to use this witness, she needs to do that now. And the state may have issue with the fact that it's late. The state said that is another reason for them to meet again on March 18th. If that's going to be disclosed this week, they can address that on the 18th. The judge asks if there's any issues with getting her fingerprints, palm prints, or photographs. Lori asks the judge for what purpose. I don't understand. The judge says if you're convicted, it may be used to prove other convictions. The judge asked the state if they are expecting to proceed with the second trial, that is the attempted murder for Brandon Boudreaux, regardless of what happens at the first trial for the murder of her 4th husband, Charles Vallow. The state says yes, but they would need around 30 days so they can send subpoenas to out-of-state witnesses. The judge wonders if maybe they should set a provisional second trial date. It should take, again, 3 weeks for the state's case. Lori says she would like to remind the court her last day for speedy trial is May 11th. The judge said he would probably exclude some time because obviously she cannot do 2 trials at once. Lori says the state could combine both and do 2 trials at once, but they don't want to. She also said it violates her speedy trial rights if they don't give her a speedy trial by May 11th on both cases. Not to mention, they did combine all the discovery into one case. They did not give 2 discoveries, which would have been more convenient considering how much there is. The judge asks if the state wants to combine the 2 cases. They say if the court wants to give them a little time to work it out, and a normal defense attorney, and then she says, I don't mean that and she goes on and says, normally they would be severed because, but the judge interrupts and says, you don't want one jury to know about the other 2 separate charges and then have a harmful rub-off effect on the evidence in one case affecting the other. The state says, hey, that's why they were filed separately, but if Lori wants them together, we have to push back slightly because the witnesses were not subpoenaed for this trial. But Lori also has to know she is waiving prejudice. Lori and the attorney who is assisting her, they chat for a second. And then Lori says, I'm not saying to combine them. I'm saying give me my second trial by May 11th. The court can figure all that out. The judge said he would waive some time over Lori's objections because she can't try 2 cases. And also, I'm not sure how much prejudice there is with the time violation, and you wouldn't be released from custody anyway. And law says any violation should be dismissed without prejudice. So, unless there is an actual prejudice shown, and in which case the state can just refile the charges. Let's set a start date for May 12th. And that could be a quick turnaround, but he doesn't think the first case is actually going to take 6 weeks. The state says they may ask for more time to get subpoenas out, but the judge says if that trial date goes any further out, he may not be on the bench. He has training in June, and then at the end of June, he's rotating. Lori asks if both parties can send subpoenas starting on May 11th, and the judge says assuming we're done with the first case by May 1st. The state reminds the judge the court needs to be dark on May 21st through the 23rd. And the judge needs court to be dark the 18th through the 21st. The state says with that whole week being dark, it really just doesn't make sense to start then. The judge is going to talk to another judge, but for now, they are going to keep that next hearing for March 18th on schedule. And at that time, they'll look at the expert report being disclosed. Lori will also have her prints done that day, but that will not be live streamed. The state has 2 motions from the defense. Motion to dismiss, and Lori's argument was she was not given a speedy trial. The other is the extradition rule. The judge said he denied the first on January 24th, and the violation of speedy trial was denied last week. He asks if there's anything else, and Lori says one housekeeping matter. NTSO has restraints that she has to wear during trial. Will I be able to stand at the podium to question witnesses or cross-examine? Can I move with the leg things and the shock vest? The judge says Lori will stay by the podium, and if an exhibit needs to be handed to a witness, that can be done by her advisory counsel. So her next hearing, March 18th at 8:15 in the morning, that is Pacific time, 11:15 Eastern. I'll live stream that. Had a lot of people ask, am I going out for trial? I'm going to be in and out, some during the state's case. And then obviously I want to be back when the defense case starts for obvious reasons. Not sure how often I'll get out there, but yeah, I am planning on going for at least a week or 2 here and there. Got a lot of stuff coming up. My son is a senior. He has prom in April, graduating in May. And of course, those things are the most important, but we'll be shooting out to Phoenix as often as I can. That is it in Lori's world for today. Hope you guys have a good rest of your evening, and we will see you soon.